Good morning and welcome to today's webinar. A very popular topic we're bringing back, understanding the uses and purposes of irrevocable trusts, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. We have many new attendees to today's webinar, so welcome to everyone. And if you're returning to see us again, thank you for your continued support as always. So currently you as the attendee are in listen only mode. However, as always, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout the presentation to address all of them. Your questions really help the presentation and add value. They help others learn. So please don't be shy in posing your questions to me at any time, and I'll get them over to Steve. You received the presentation yesterday by email for me to take notes if you wish. If for some reason you did not receive the presentation, it is available in the section marked handouts in the panel on your screen to download at this time. For our professionals on today's presentation, welcome as well. For CFPs, CPAs, and others on today's webinar, you may receive 1.5 continuing education hours for attending. So per my attendance records requirements, please email me your ID number if I don't have it already. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, and we do ask that you please just take a couple minutes to fill out this very simple survey to give us your feedback about today's presentation, and we read and value every comment that you share with us. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have now or in the near future. And here at Elville and Associates, we always look forward to being a resource to you at any time. So briefly, as we have a lot to cover here today, I'd like to share an overview about our firm and share a little bit about Steve. So let me share my screen here briefly. There we go. So Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have many different practice areas here that we offer to our clients, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville & Associates, and that's one of our main focuses here. We do that in many ways, through our planning processes with our clients, through over 100 educational webinars and workshops in the communities we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day. A little bit about Steve. His work as an attorney for the past 20 plus years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. A very seasoned speaker, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 7th time in 2022 and a 6th consecutive year, so congratulations to Steve. And also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me, and I'd be more than happy to share our story with you when we have a little bit more time. So With all that said, I'm going to go ahead and turn it over to Steve. And Steve, I'm going to make you the presenter. You should see that button pop up here in just a second.
All right. Thank you so much. I am going to switch screens now, and we will get started here just momentarily. And I'm going to go to my slideshow. And there we are.
Looks
all right. Good morning, and thank you, Jeff, for that wonderful introduction. And good morning to everyone. It's a beautiful day here in Maryland. I hope no one's in Florida in harm's way. We wish everyone there the very best and what may happen from this pending storm. But we're here in a beautiful day, and I'm looking out of our conference room 3 here in Columbia, and I hope you get outside today. Your time is very valuable, and I feel privileged to be with you this morning to share a special time with you on this Wednesday morning. And I want to just say, as we get started, we're not going to take a lot of time in introductions this morning because I've got a lot to cover with you. And this is more of what I would call a roll up your sleeves, get your pen or laptop out to make notes kind of workshop. So we put this workshop on last year, and by popular demand, we're bringing it back again. And I hope that you will view this as sort of a mini masterclass on what kinds of trusts are available out there. Knowledge is power, right? So if we have an idea through education, if you're a professional, continuing education, client education, if you're a non-professional, and most of this workshop is geared towards clients or prospective clients, but also for the professionals on the line. Obviously, there are certain aspects of this material that are going to be very important and valuable to you. So we're going to try to give something to everyone here on the webinar this morning. I just want to say before we launch into the material, Jeff is an expert moderator. He understands how to interrupt me and ask questions, or if you have a special issue, a technical issue or anything, please let Jeff know. If you don't have the materials, please let Jeff know that as well. And with that said, I thank you for your valuable time this morning, and I hope you will walk away from today's workshop with some substantive information you can use about irrevocable trusts. So we're going to look at what's happening in estate planning in 2022. You know, here we are at the end of September. It's hard to believe. I was in a Lowe's over the weekend. I was in another Target, and I'm also seeing the October Halloween paraphernalia. I'm seeing the Christmas trees up. It's really fall. We're into the year, the busy time of year. Why should clients care about irrevocable trusts in 2022, or advisors, by the way? What is the difference between a revocable and irrevocable trust? We're going to really drill down into the basics. What are the most common and available irrevocable trusts in 2022? And what are the uses and objectives of these types of trusts? Now, as an ancillary issue, we're going to be talking about the taxation of irrevocable trusts. This is a very brief discussion because it's a broad topic. And we're also going to be talking about the need for flexibility. You know, what are we blessed to have in new trusts versus what are we dealing with older trusts and their lack of flexibility. So we're going to get into all this, and I, again, encourage you, don't get overwhelmed. We're going to move through the material fairly quickly. Take what you can from this. Write down your questions. Because of the volume of material, we're going to have to move quickly, but we're always going to be here to answer questions later, to meet with you one-on-one, whatever may be best to be able to be of help. So we continue to have a legislative stasis, and I guess the reason I'm saying that is with all the buildup from 2021 and the Building Back plan and how that stalled. Well, it's been a wonderful thing that it stalled for various reasons, because we didn't lose the step up in basis, which we're seeing here in the next bullet point. We didn't lose our huge exemption amounts, which are still on the table, at least temporarily. We didn't lose a lot of the benefits of irrevocable trusts that we're going to talk about today. So many people are happy that this came to a screeching halt. These huge legislative agendas in 2021 that actually made us all think very seriously from the early part of 2021 all the way through maybe October or November of 2021, that really big things were going to happen in the world of estates and trusts with regard to the legislation. But the tax rates basically remain unchanged. The uses of grantor trusts remains relatively unchanged, and estate and gift tax rates are unchanged. So we are still in a very, very wonderful environment for estate planning in September 2022. Huge exemption amounts, and this cost basis adjustment of death survives, and the uses of grantor trusts largely survive as well. So we have lots of opportunities for basic and advanced estate planning. And again, we talked about this reprieve from the changes. All these things appear to be on hold. Everyone I talk to in the world of estates and trusts has no different opinion than that. I don't think there's any secret information out there that we should be aware of. I think basically we are on hold up until 2026, pending other legislation, other political changes that may occur. We will just have to wait and see, as we always do, each and every year, each and every quarter, what is happening in the world. So again, we talked about grantor trust. We're going to talk about what that is. Life insurance as a tool. The use of life insurance and life insurance trusts are just as important today as they've ever been. And of course, we have time to continue to think through the income tax and estate tax issues. One of the things about this holding period that we seem to be in is that we have the time to sit and think a bit. We're not under pressure as we thought we were in 2021. So for individuals of wealth, we're not under pressure. We have the time to think. Now, what is the difference between a revocable and an irrevocable trust? And we're really drilling down into basics. So for those of you who are not familiar with this concept, a revocable trust, or what is called a revocable living trust, is nothing more than a substitute for a will. So in basic estate planning, we talk about wills, we talk about revocable trusts, and the revocable trust avoids probate if it's properly done, if it's properly aligned with the assets in that person's estate. How are assets titled? This is one of the most important questions, if not the most important question in estate planning. But with a revocable trust, if we don't have those assets funded properly, aligned properly, however we want to say it, including business assets, corporate assets, if we don't have those assets aligned, the plan will fail. But we have to remember that a revocable trust has no asset protection. It has no income tax savings, okay? It can be changed by the grantor. It can be terminated. It can be revoked. And the grantor trust simply says this: the grantor pays the income tax, not the trust. And so the revocable trust is the most basic form of a grantor trust. Notice if you have a revocable trust or you're thinking about it, Uncle Sam ignores the revocable trust for tax purposes. So Uncle Sam does not treat you any differently if you have a revocable trust versus if you did not have a trust. So these are some of the basic fundamentals of a revocable trust. Now, the irrevocable trust, on the other hand, there are many ways to describe these things. And I think for educational purposes, I like to describe the irrevocable trust as a trust that is created for a special purpose. So a good example, of course, you're going to see these examples throughout the presentation, but a good example would be a charitable trust or a special needs trust, and we won't go into more details there. These are trusts that are created for a specific reason, and that's why I say they have a special purpose. These tend to be the irrevocable trusts that we talk about. Now, irrevocable trusts do avoid probate if they are properly funded with assets. They can provide asset protection for the beneficiaries, and generally do if they're structured right. They can be created during life or at death. Remember, we're juxtaposing the difference between a basic revocable trust and an irrevocable trust. And it can be a grantor trust, and there are many reasons why the grantor trust rules are very favorable, where even though the trust is irrevocable, the grantor pays the income tax. Or it could be intentionally structured as a non-grantor trust. This is the trust that pays its own income tax, and as a separate discussion, income tax rates for trusts are much higher and they have to be managed. But the irrevocable trust can remove assets from the taxable estate, and it can also provide income tax advantages. Whereas if we use a revocable trust, we are not removing assets from our taxable estate, and that's just a basic difference between those two vehicles. So what are the most common and available irrevocable trusts in 2022? Well, these are some of the things we're going to talk about. We're going to talk about irrevocable spendthrift trusts, that's a mouthful, created at death. So we know we can create trusts at death. Lifetime gifting trusts, these are irrevocable trusts. Life insurance trusts, trusts that remove life insurance value from the estate, and they have other benefits. Spousal lifetime trust, or what is called the SLAT, spousal lifetime access trust. These are very popular vehicles for exemption planning, people giving large gifts to their spouses and thereby getting those gifts out of their taxable estate and also utilizing their exemption amounts. Charitable trust, we talked about that briefly. Now, on the elder law side, the elder care side of the fence, Medicaid and Veterans Trust, these are irrevocable trusts. Marital trusts and bypass trusts, these are trusts created at death or trusts that can be created during life. The grantor retained annuity trust, or what is called the GRAT. This is a vehicle for removing taxable estate assets out of one's estate. Special needs trusts, these can be irrevocable or revocable. Minors trusts, education trusts, dynasty trusts. These are lifetime bloodline type trusts. Domestic asset protection trusts. These are the vehicles in the asset protection states like Delaware, Nevada, Wyoming, South Dakota, Alaska, and many other states are asset protection type states. Special power of appointment trust. These are kind of a hybrid version of irrevocable trusts for asset protection that have special features. And community property trusts. These are trusts that can be used even if you don't live in a community property state. These are trusts that can be used to gain the advantages of a community property jurisdiction. Qualified domestic trusts. These are trusts for non-citizen spouses. So this is fairly common and has been used for years. A qualified personal residence trust. This is a trust that's irrevocable to remove the value of a second home, for example, or even a primary residence, but usually a second or third home out of the estate at a discounted value. We're going to talk about that. A crummy trust, and this is always where we try to laugh as much as we can in estate planning when we find something to laugh about. The crummy trust, which we'll get into. The quiet trust, what is that? And of course, a standalone retirement plan trust. What are we doing with IRAs and other types of retirement assets at death? And we can have those drive into a standalone retirement plan trust. So we're going to talk about all of these. All right, so let's talk about the first one, trust at death. Now, one of the nice things about estate planning is that we can obtain asset protection at death. We can obtain protection of our beneficiaries, whether they are spouses, children, nieces and nephews, whoever it may be. We can protect them, and we can create these either during life or at death. And here in this example, we're creating trusts at death, trust under our will, trust under our revocable trust, okay? So let's talk about some of these types of trust. But before we get into this, let's talk about what a spendthrift trust is. So this doesn't mean that your beneficiary is a spendthrift. It doesn't mean you're a spendthrift. It just means that it's a theory of law. And the one case that I've seen since I've been a young lawyer is a case from the 1800s in Maryland where someone actually passed away in the middle 1800s and they left their child a trust. And this person, from what I understand, this man was not a nice person. He was a criminal. He was just a horrible individual. But his mother still saw him as her son, and she left a trust for him and said to the world, this trust is for his benefit. It can't be invaded by creditors. It cannot be invaded by people who he has done wrong to, and so forth. And this was the beginning of the spendthrift law in Maryland, where you can say in your will or trust, you can say this is protected from the beneficiaries, creditors. And why is that? It's because the beneficiary of the trust does not have the ability to give away or assign away their interest to creditors. So what I like to do is think of the spendthrift trust as a trust where there is a trust for the individual. I put a dollar sign right here in the middle, and there are walls around this money. And those walls, because of the spendthrift provision, plus other types of features of such a trust, the spendthrift trust is one of the features that protects the trust from the claims of creditors. Now, there are exceptions to the spendthrift trust rule. There are exception creditors, and we have a lot to cover, so I'll just be brief here. But spendthrift trusts do not protect claims for alimony, child support, or taxes. So Uncle Sam or a spouse, or an ex-spouse, I should say, that has the right to public policy driven benefits like alimony or child support can invade this trust, but it does protect against most other creditors. So examples of this kind of trust are a Q-tip trust, or what is called a qualified terminal interest property trust. These are trusts created for spouses by another spouse who died at their passing. A bypass trust, this is a non-marital trust, and we'll get into more of that later, but these trusts are created at death. These are spendthrift trusts that protect the beneficiary from creditors, provided that the trust is properly drafted in other respects as well. And again, these are used for control, protection, and management for children, also grandchildren, nieces and nephews. And this kind of trust at your death or at the client's death, person's death, is a non-grantor trust. So these are trusts created at death. They have a life of their own. They have a tax ID number. These trusts are non-grantor trusts, and they pay their own income tax. Now let's talk about lifetime gifting trusts. So we're moving right along here. You may be, or someone in your life may be, a person who wants to make lifetime gifts, but they want to make gifts to a trust. They don't want to make outright gifts. So a person can actually make a lifetime gift to establish a trust for a spouse, a child, a grandchild, niece or nephew, friend. And this could be a lifetime Q-tip trust. Now, this is that marital trust that I just spoke about. So most people think about the marital trust as only between spouses and only at the death of one spouse. But a lifetime Q-tip trust could be created, and Maryland is a jurisdiction where a lifetime Q-tip trust, meaning a gift from one spouse to another spouse in further trust during life, under the Q-tip rules, can be a very, very strong asset protection vehicle. So for the right person, this is a very underutilized tool. For the right person, this can be powerful. And then more common trusts, a grandchild's trust that is established during life, an education trust that's established during life, where we gift money into these trusts during life. A charitable trust could be a gifting trust. When someone wants to establish a charitable trust for various special purposes. And there are whole other webinar series on the different types of charitable trusts. A dynasty trust, a trust that is meant to last for generations, what is called a generation skipping trust or a bloodline trust. And these trusts can be established as either grantor or non-grantor trusts for income tax purposes. All right, moving right along, we're talking about now life insurance trusts. So we've moved from what is the difference between a revocable and an irrevocable trust through the first few types of irrevocable trusts, and now we're on to life insurance trusts. So life insurance trusts basically are tools. They are usually created, as you'll see in the last bullet point here, they are usually created as grantor trusts, meaning the grantor is paying any income tax on that life insurance trust. Doesn't have to be, but usually is. And properly drafted, this usually removes the value of life insurance from the estate of the person. So for those of you who are following as closely as you can, let's pretend that someone comes in to see us here at Elville and Associates, and they say, Steve, we just purchased a new $5 million life insurance policy. Or there's a reason why this person needs a large life insurance policy. Well, if that policy is owned by the trust, if that life insurance trust is created and that life insurance trust actually owns the policy, that life insurance trust actually purchased the policy from inception, from the time it was created, then all of the life insurance, that 5 million or 3 million or whatever it may be, that value is removed from the estate of the person, and Uncle Sam cannot tax that at 40% estate tax as an addition to that person's gross estate, meaning the amount in their estate. Now, this is either in a first to die kind of scenario where someone has a single life insurance trust, or it can be a second to die life insurance where the life insurance is purchased on the life of both spouses in a spousal situation, and that tends to be less expensive, and it's going to pay out on the second person to die's estate. Now, it provides control for the grantor, it provides protection for the beneficiaries. It also can be used to leverage gifts. Let's say someone creates a life insurance trust, and what do we know about life insurance trusts? We have to fund the premium amounts into the trust. And let's say that is done. But let's say that there is more room, so to speak, for gifting. And let's say the beneficiaries of the trust were 4 or 5 different types of beneficiaries or persons. Well, now we could take 4 to 5 times the annual exclusion, which is $16,000 per person, and that person could actually gift tax-free, could gift those annual exclusion gifts into the trust. And if those annual exclusion gifts exceeded the premium that was due, that person would also be succeeding in removing assets out of their estate, not only to pay the life insurance premiums, but also to get money out of their estate and gift it for gift purposes to the beneficiaries of the irrevocable trust. The life insurance trust is also a tool to deal with the taxable estate. That's a lot of the reason why someone would want to purchase life insurance, move those assets out of their estate, but still have the money available to their beneficiaries to pay for estate tax if there was going to be estate tax, or to deal with income tax. For example, the Secure Act. The Secure Act, what do we know about that? It's going to, as we move forward from 2020 and the implementation of the Secure Act, it's going to cause immediate taxation, or what I should say, I apologize, accelerated taxation on IRAs. So those IRAs for healthy beneficiaries are going to be taxed in 10 years or less. And now the question with use of life insurance trust is, do clients or prospective clients want to use life insurance as a vehicle to deal with the acceleration of income tax for their beneficiaries under the Secure Act? And it also could be a tool if we were to ever lose the step up in basis, which we have not. So we always want to keep that in mind, that life insurance, we like to say, is the Swiss Army knife in estate planning. It's got many uses, and we always want to keep this potential tool in mind and the use of the irrevocable life insurance trust. Now, we'll go one more example here with a different irrevocable trust, and then I'll stop to see if there are any questions before we continue on. So as we continue through the litany of irrevocable trusts, let's talk about the SLAT, the Spousal Lifetime Access Trust. So this is a popular tool for spousal exemption planning. What do I mean by that? Well, each spouse, if you're married or you know someone who is married, each spouse has a $12,060,000 exemption amount right now for federal estate tax. This is adjusted for inflation, but between the two spouses, properly used, if they haven't already used their exemption amounts, these are $24 million of exemption. So this morning I was on a call with a client who is going to use at least one SLAT. They're going to use maybe 2 total, and they're going to remove somewhere between $12 million and $24 million out of their taxable estate. And the wonderful thing about the SLAT is that it not only removes it from the taxable estate, but all future growth is going to be excluded from the taxable estate. So what that means is, let's say $24 million is removed from the taxable estate and it grows inside of the trust. It is invested inside of the trust. It has income inside of the trust. Well, all of that growth is estate tax free if it's properly done. Now, again, this is used for the temporary exemption. So we refer to these 12 million exemptions. And by the way, Maryland has a $5 million exemption, but here we're talking about the larger federal exemption. And we use this for not only removing those assets out of the estate, while leaving the grantor spouse, the spouse that creates that trust, with some modicum of control over those assets. There is a way to do that, and their spouse and their children are the beneficiaries of the trust. Now, it's also for asset protection, or what we call creditor protection. And these types of trusts can be done in Maryland as the jurisdiction. It could also be done in Delaware or one of the domestic asset protection trust jurisdictions. There is a loss and step up in basis. So these gifts do not provide the recipient spouse and children with the step up in basis. So there's this loss of the step up in basis. So that's not good. And we're not very happy about that. But that doesn't seem to stop a lot of people from thinking this is a very advantageous strategy to do the lesser of all evils, the greater of all evils, and that is removing the assets from the taxable estate at 40% estate tax with the corresponding loss of step up in basis. So as I mentioned, the spouse and children are the beneficiaries, and in some jurisdictions, the grantor, the person who gave away the asset, can be added back as a beneficiary in the months following the establishment of a trust. Now, the mechanics of establishing these trusts are critical. Where we have spouses, we don't necessarily want to create these trusts at the same time. We don't want to necessarily create them in the same jurisdiction. So we do need to stagger the trusts. We want to avoid the onerous IRS rules that might say these trusts are reciprocal or these trusts are established and they're just going to be ignored for IRS purposes. We don't want that to happen. So we want to establish them in a way where they are clearly for estate planning purposes and they are not going to be discounted as reciprocal trusts. And as I may have mentioned early on, these trusts are established as grantor trusts for income tax purposes. So not only does it remove a large gifts from the estate and allows those assets to grow tax-free and never be taxed again for estate tax purposes, the grantor can retain what is called the grantor trust rules for income tax purposes, and the grantor pays the income tax, which is much more favorable than if it were a non-grantor trust. All right, Jeff, I'm going to stop for just a second. We've been going now for about 30 minutes, and I'm going to see if there's any questions before I forge ahead.
Okay, thanks, Steve. Doesn't appear we have any questions as of yet. I appreciate you checking though.
Thank you so much, Jeff. All right, and I thank you again for hanging in there with me. This is a lot of dense information for particular irrevocable trusts that you're interested in. I hope that you'll be able to drill down and take away something. Otherwise, I'm just going to keep covering the basics of the irrevocable trust list that we have established.
Actually, Steve, 1 second, if you don't mind. If you're somebody, just email the question to me. If I could read that to you, that'd be great. So it says, you referred to the accelerated distributions from IRAs related to the Secure Act. If a child inherits a traditional or a Roth IRA from a parent, must the child take distributions from the IRA in years 1 through 9?
Well, thank you for that question. All of these types of general answers that I can provide today, you can't take those as legal advice because I don't know the particular situation. But my understanding from the February 2022 temporary regulations seem to suggest, the IRS regulations, I should say, seem to suggest that Uncle Sam wants that to happen. They want some withdrawal in substantially equal amounts over those 9 years. So my off the top of the webinar comments this morning would be yes, that would be my interpretation of that. For that person who is considered to be a designated beneficiary, meaning they only have 10 years to take the asset out and it has to be taxed. Thank you for that question.
Thank you.
Okay, let's talk about charitable trusts now. Now, there's lots to talk about in charitable planning, but let's just talk about the charitable remainder trust. This is the trust that we can have different variations on this theme. It's a wonderful tool. It can be established for 5, 10, 15, or 20 years, or for the lifetime of the beneficiaries, because there are lifetime beneficiaries and then there is a charitable remainder. So if you are charitably minded, this is a wonderful way to get a current income tax deduction to also avoid capital gain. So let's talk about that. Let's say that you have a low basis asset, an asset that has a very low basis, but you are also very charitably minded. What you can do is you can contribute, I should say, that low basis asset to the trust. You can sell that asset inside of the charitable trust, and you can avoid capital gain. So the IRS wants to incentivize you to do a charitable remainder trust if it's appropriate for you. And you can retain an income stream yourself, and it's just going to be a question of how many lifetime beneficiaries do we want to have? Is it just going to be you or you and your spouse that receives a lifetime income, or is it going to be your children as well, with a corresponding charitable remainder at the death of the lifetime beneficiaries? And of course, the more income beneficiaries we have, the lesser our charitable remainder is going to be. But we get a charitable gift tax deduction, and also that offsets our taxable estate. So a charitable remainder trust is a wonderful tool, and it also can be used to deal with the Secure Act, and that's beyond the scope of today's discussion. But someone who is charitable minded, now you wouldn't want to do this if you weren't charitable minded. If someone were charitable minded, they could leave an IRA to a charitable remainder trust, and they could simulate potentially a greater lifetime stretch out of income to the lifetime beneficiaries as a potential way to deal with the Secure Act, but only for purposes of someone who is charitable minded. And this is a non-grantor trust for income tax purposes. Now let's switch complete gears to elder care and elder law. So let's talk about the Medicaid trust and the Veterans Trust. What are these? Well, these are popular tools in elder care planning, and they started being used, to my knowledge, somewhere around 2005. And the elder law community created these trusts, and these trusts are hybrids. They are used as control mechanisms. So let's say that someone wants to divest themselves, gift assets away from themselves for purposes of Medicaid planning. Well, this trust can be used as a control mechanism. The person does not have to use a trust at all. The person could divest themselves of assets and make outright gifts. The problem with that is several things. The person is going to potentially lose the step-up in basis at death because they made a lifetime gift and they have a transferred basis. Now, if a person makes cash gifts to another person for elder care planning, there is no basis issue. But if we want to preserve the step-up in basis, we want to use a trust because we can do that. This trust is typically drafted as a grantor trust if it's a Medicaid trust. Now, one of the big features is also that the person can retain a modicum of control. So the person retains the right to change trustees or to change beneficiaries. And that provides the basis for not only some control, very limited control, but some level of control, but also triggers the step up in basis so we don't lose that. Perhaps one of the biggest attractive features of a Medicaid trust, and I'll talk about the Veterans Trust in just a second, is that the Medicaid trust allows you to gift assets into this irrevocable trust, and that trust is protected, or the assets of the trust are protected from the claims of the beneficiaries. So let's say that we are gifting assets to a Medicaid trust for children, for the benefit of children, but one of the children gets divorced. Well, that divorcing spouse might try to go after that child's assets. But with the Medicaid trust, there is a shield of protection around the beneficiary's assets that you have gifted into that trust, so that divorcing spouses or other creditors could not penetrate that trust and be able to get the assets. So we call this a Medicaid trust. Now, for veterans, we have what is called a Veterans Asset Protection Trust. This is a hybrid of the Medicaid trust. We know that the Medicaid laws and the VA laws about the Veterans Asset Protection, and I should have said the Veterans Aid and Attendance Benefit is what I meant, the Medicaid benefit versus the veterans benefit. And the VA has many, many types of pensions. So the veterans aid and attendance benefit, or the VA aid and attendance benefit, is a tax-free income. So many veterans will use a trust to get assets out of the veteran or the veteran spouse's name for purposes of facilitating qualifications for VA aid and attendance benefits. A good example of this is a recent example where I represented someone who needed to transfer their real estate out of their name into a VA trust, and that allowed them to get qualified for VA benefits. This was a surviving spouse. Now, the VA trust is a hybrid in the sense that it is a grantor trust for one side of the trust, and it's a non-grantor trust for the other side. And to make a long story short, the reason for that is, in this particular case, for example, real estate needed to be transferred into the trust, and it needed to be sold right away. And when that property is sold, we don't want to give up any of the capital gain exclusion that the surviving spouse was entitled to. So by transferring that into the Veterans Trust and using the grantor trust portion of the trust for that, the person was able to sell through their trustee, was able to sell the house, create cash. That cash is now deemed to be in the non-grantor trust portion of the trust. And now that is a gift that starts the process of two things. It starts that person being eligible for veterans benefits. It also starts the 5-year period for Medicaid. Remember, Medicaid has a 5-year, 60-month look-forward period, and that period is what we need to get through to be able to divest assets and then be able to apply for Medicaid with no penalty. So the Veterans Trust hits those two birds with one stone for the right person. So this is a very, very brief overview of Medicaid and Veterans Trust, but just to give you a sense of the person who, for the person who wants to divest assets, these are some of the most powerful tools in estate planning today because of their flexibility under the current laws. Now let's talk about a marital Q-tip trust. We talked about this in the beginning. Now this is a tool that is very popular. Why? Well, we have two types of ways of thinking in marital planning if you're a married person or you have a client who is a married person. So I want to kind of draw a very simple illustration here using my hands. So let's say that this is a deceased spouse, and that deceased spouse is leaving assets in this direction for the marital share, for their surviving spouse. That is called the marital share in a very, very simple way of thinking. So anything that is going towards, in my simple way of thinking, the surviving spouse, I would call that, just for purposes of education, that's the marital share. Because Uncle Sam says that if you are married, you get to take advantage of something called the unlimited marital deduction. And what that means is, if you leave assets in this direction, so to speak, you can have the best of all worlds. If you're the deceased spouse, you can control the assets that you're leaving your surviving spouse if you want to, through the use of a marital trust. But those assets will actually be taxed in the estate of the surviving spouse, not in the estate of the deceased spouse. So my simple-minded way of looking at the marital Q-tip trust is that it's a control mechanism for the deceased spouse to do two things. It's designed to provide asset protection for the survivor, because remember, the surviving spouse does not enjoy the tenants by the entirety's protection of husband and wife and so forth for spouses. And so that is lost upon the death of one spouse. So that protection, at least in the marital trust, can be reestablished by using that trust. And the Q-tip rules say that if you're going to take advantage of this unlimited marital deduction, the surviving spouse must get at least all income of the trust. So for example, let's say someone left $10 million into the marital Q-tip trust. The surviving spouse could be given only income. You only get the income of that trust. Now, of course, the income on $10 million would be quite a lot. But most spouses say, well, my surviving spouse gets income and principal. So at the survivor's death, the assets go down to the further beneficiaries that the deceased spouse specified. and those are usually children, or they can be nieces and nephews or others. Now, why is that so important? Well, because that is also marital protection. So the person who leaves a marital Q-tip is taking advantage of the unlimited marital deduction, taking advantage of asset protection, but also protecting against the remarriage of the surviving spouse by making sure the assets go downstream to the further beneficiaries. Now notice that the step up in basis is maintained, and the person who takes advantage of this wonderful mode of planning, which is what most married couples should do, generally speaking, it does provide for not only one step up in basis at the first death, but 2 steps up in basis at the death, meaning a second step up in basis at the death of the surviving spouse. So this is a very powerful way of thinking, as opposed to leaving assets to the non-marital share. And we'll talk about that a little bit later. So this allows, again, control. It's a powerful tool. Now, let's talk about the Q-tip trust during life. So one of the most underutilized tools in estate planning in Maryland is the use of a lifetime Q-tip trust. Spouses say sometimes, well, how do we obtain the most asset protection possible? Well, let's review that real quick. We have asset protection in IRAs, 401ks. We have asset protection in life insurance. We have a basic level of asset protection in tenants by the entirety's property between married couples, and that should also include brokerage assets for those who are not thinking in terms of that. It's not just real estate. It can be brokerage assets that are titled as tenants by the entireties. Annuities are protected from the claims of creditors, just like life insurance, as long as a spouse or child is named as the beneficiary. But now let's say someone wanted to go beyond that, or let's say that one spouse was much wealthier than the other, and they wanted to equalize assets during lifetime, but they wanted to hit 2 birds with 1 stone, and they wanted to provide great asset protection during lifetime. So what they can do is contribute to a marital Q-tip trust under Maryland law, and that other spouse, the recipient spouse, will have wonderful asset protection in that asset inside of that marital Q-tip trust. And at the death of the surviving spouse or that recipient spouse, the assets will go down to the persons or organizations that the gifting spouse specified. So this is a non-grantor trust for income tax purposes, and this is a very powerful tool for the right person. And before we move on, I just want to say again, one more time, just for clarification, the marital Q-tip trust can be used at death, in wills or trusts. It can also be used at during lifetime for advanced estate planning. Now let's talk about this non-marital trust. Now, this used to be a very popular tool. It still can be used. So let's pretend now in my very simple example, one spouse passes away and that person could have left assets in this direction, the unlimited marital deduction, leaving assets for the benefit of a surviving spouse, but they chose to leave assets in the opposite direction. We call that the non-marital trust. Now, this does get a cost basis adjustment, a step up in basis on the death of the first spouse, but it does not give a second step up in basis, so it's less favorable for income tax planning. Now, it does protect the surviving spouse from creditors. It controls the assets for the first person to die. They're going to leave these assets downstream to the persons they want, but it is not going to be as good for tax purposes. So the person who does this kind of planning is a person who maybe wants greater protection from spouses remarrying, because in a bypass trust or a non-marital trust, you can require a prenuptial agreement for the surviving spouse, whereas in a marital trust, the rules say you can't restrict marriage, you can't do that kind of thing and still qualify for the unlimited marital deduction. So we won't spend a whole lot of time on the bypass trust or the non-marital trust. For the vast majority of people, with some exceptions, the vast majority of people should plan, if you're married, by way of the unlimited marital deduction, either leaving assets outright for a surviving spouse or leaving assets in a marital trust. But there are circumstances and clients that do require that we use a non-marital trust. So that is just something I wanted to bring to your attention today. And Jeff, I'm checking my time, so we hopefully will continue to move through here judiciously. Let's now talk about. Yes, go ahead, Jeff.
Can we address a few questions that came about from the last few trusts you talked about? Okay, thank you. First question is, if a rental property is left to a charitable remainder trust, would capital gains tax be owed on any depreciation taken prior to donating the asset to the trust?
Well, I can say that if you contribute a rental property with a low basis to a charitable remainder trust, then you would be able to sell that with no capital gain. I wouldn't be able to answer the depreciation question, through this medium, but we'd be happy to look at it or even meet with your CPA to analyze that question.
Okay. Is the cost of maintaining a trust a % of the assets in the trust?
Well, that's a great question. I'm going to say, as a kind of off the top comment, that there shouldn't be any costs of maintaining a trust other than tax preparation, because remember, trusts have to have tax returns filed each year. That's a broad topic. If there is a trustee, the trustee is entitled to compensation, okay? So it depends on how that trust is, what kind of trust it is. And of course, there should be maintenance of the trust. As we're going to see before we get to the end of the workshop today, irrevocable trust in today's world can actually be changed. They can be modified in certain ways. And so there could be legal fees because updating needs to be done. There could be special fiduciary fees, but it just depends on how long the trust is in place, what kind of trust it is. Certainly there are some potential costs and there are some hard costs in most cases for maintenance of the trust, but in some cases it would be more than others or less than others.
Okay. If a rich wife sets up a Medicaid type trust for teenage children and then divorces her husband years later in a community property state, were those assets transferred into the trust protected from the need to share them 50-50 with the now divorced husband?
Well, thank you for that. A very interesting question. I'm fascinated by the question. My initial response, because I won't be able to answer that community property question, I apologize over this medium, but I will say I thank you for the question, and I would just say it sounds to me like that particular case where the wealthy spouse did the Medicaid planning, I would think that the other spouse, the non-gifting spouse, should have been taken into consideration as part of that process. And there may have been reasons because of the wealth that you emphasize of the gifting spouse. There could have been reasons why the other spouse was not included in that type of planning or the consideration for the spouse. So sounds like a very complex situation, and I would have to research it offline with you or meet with you in person.
Okay. One more question. Let me try to read through this here. It says, elder trust pros and cons effect on in-facility care, i.e. nursing home.
Well, if I take the gist of that question, let me try to answer it. If a person has a goal, it has to be for the right person that has the goal of preserving assets from nursing home spend down. So if that situation is correct and the goal is correct, then a divestment of assets can occur, and that will start a hypothetical 60-month period. We would like to think in terms of a look forward period. So many times we use the term look backwards or look back period, but we ought to look forward from the gift. Now the question becomes, the person who does this planning, do they have enough assets in reserve to get through the 5 years? So whatever has been gifted, do they have enough assets to get through the 5 years? Because if they don't, now we have a problem. We may not be able to get through the 60 months if a crisis occurs. So we want to have, ideally, some assets in reserve, or we want to have long-term care insurance in reserve, just in case we have a crisis going through that 5 years. But if we can get past the 60 months, now we've passed the test under the current law, and a person is able to then apply for Medicaid long-term skilled nursing benefits. In Maryland, we call that medical assistance. And there would be no penalty for the gift that was given that started the 5-year period. I hope that's helpful.
Okay, thank you very much, Steve.
Thank you, Jeff. All right, moving now, because it's 5 till 11 and we want to make sure we end and have plenty of time for questions. The grantor retained annuity trust. This is the GRAT. Now, this is a tool to remove assets from the estate, but it is not a huge exemption planning tool. This is not a tool where you remove $12 million from your estate. It's basically a gift to an irrevocable trust, and it is a arbitrage, so to speak, and I'll just try to explain it briefly because it's a very complex tool. It basically pays an annuity payment to the grantor of the trust, and it's a measurement of how much growth can be achieved during the trust period. And if that growth exceeds what is called the IRS 75/20 rate, then anything that exceeds that is excluded from the grantor's estate. So this is what we would call an estate tax play, so to speak, that we're trying to get certain amounts, usually smaller amounts, but not always, out of a grantor's estate. So it is not going to be a tool to use to get 12 million out of the estate or 5 million out of the estate per se. It is a strategy for an individual to be able to use this arbitrage to get certain amounts out of their estate. A minor's trust is, of course, a trust for someone under 21 years of age. The trustee has discretion over the trust. This is obviously an irrevocable trust. The beneficiary has no crummy withdrawal rights until age 21. So what is a crummy withdrawal right? Well, we're going to get to this a little further, but it just basically means that the beneficiary has the right within a certain period of time to withdraw funds from the trust. So if funds have been contributed to the trust and the grantor of the trust wants to take advantage of the IRS rules with regard to the annual exclusion, if we want to use the $16,000 per year exemption or exclusion, I should say, then the grantor has to give notice to the beneficiary, and the beneficiary has to have what is called a present right of withdrawal. And of course, that's a very scary thought that someone that's 21 or 22 years old would have this right of withdrawal. But as a good beneficiary, in theory, the beneficiary does not take that right of withdrawal. And now the grantor of the trust is able to use the present $16,000 gift and utilize the exclusion amount and advantageously be able to fund a trust. So that's what the crummy withdrawal right is. I will tell you a very quick story. Mr. Crummy, in the 1960s, he was a gentleman that had many children and grandchildren, and he had a life insurance trust. And he wanted to make contributions to his life insurance trust by using his annual exclusion gifts way back when. And so he went to the tax court and he argued that he should be able to use all of these exclusions for all of his children and grandchildren, and he should be able to remove assets from his estate by gifting those annual exclusion gifts into his life insurance trust, as we mentioned a long time ago in this presentation, to use a life insurance trust not only to pay premiums by gifts, but also to have gifts come out of your estate into the trust for gifting purposes. And the IRS agreed with him ultimately and said, so long as the beneficiaries have a present right of withdrawal, then your gift qualifies for the annual exclusion. So that's where the crummy withdrawal right came from, as there actually was a man named Mr. Crummy, as funny as that is. All right. And of course, the trust continues or terminates as specified in the document. This is a minor's trust, just to cover that very briefly. An education trust is something that is a tool for grandparents or others. It can be compared to the advantages of a 529 plan as to whether the education trust has value. It can be implemented at life or during life or at death. It can be multi-generational. It can be philanthropic. Over the last few years, we've done several education trusts that were really, really important to the grantor, that they were leaving a legacy. And the tax treatment depends on the type of structure. But these trusts that I'm referring to either could be simple or they could be complex, multi-generational, and even philanthropic type trusts. Now, special needs trusts are tools. These are for this high purpose that we are very privileged to be involved with here at Elville & Associates, special needs planning. And this is an essential tool because a special needs trust in today's world is usually going to be drafted, as a revocable trust, meaning that it has the advantage that it does not have to have a tax ID number for most families. It doesn't have to have an additional tax return prepared during life. But at some point, whether that trust is funded now or whether the trust is funded later at the death of the family members, meaning the parents, the trust will become irrevocable. And that's why we're including it here as a type of irrevocable trust. So this is for a person with disabilities or a person with chronic illness. And again, it's irrevocable either upon creation, or it can be structured as revocable and will become irrevocable later. Now, why is that so important? Well, it must become irrevocable at some point. And just for example, a person who has died and is leaving an IRA into a special needs trust, for that IRA to be treated properly at the time of the person's death, the special needs trust must become irrevocable at that time. So it protects the means-tested benefits of the beneficiary, and it's a lifetime management tool. So I want you to think about a special needs trust is, here's the person with disabilities, and the world of public benefits, for better or for worse. This is what we're dealing with. We're very thankful that there is a world of means-tested benefits. It doesn't look like it's going to go away anytime soon. This is the world that supports people with disabilities. Now, the special needs trust, or what we would call the third-party trust. You'll notice at the bottom, there is a third-party trust, there is a first-party trust. The third-party trust is really the most common trust, and this is what we call a supplemental needs trust. That third-party trust is created for the benefit of the beneficiary, and it creates another world of support underneath, in my opinion, underneath the world of special means-tested benefits. So that's what we're creating, is that lifetime management tool. Now, we've mentioned the Secure Act a couple of times. Persons with disabilities, persons with chronic illnesses are exempt from the Secure Act, meaning that they are what is called eligible designated beneficiaries. The special needs trust or supplemental needs trust is also an eligible designated beneficiary if it's properly drafted. So we need to make sure that in the world of using irrevocable special needs trusts, that when an IRA comes into that trust at the person's death, who was the plan owner of that IRA, when it comes into that special needs trust, we need to make sure that the special needs trust is also exempt because it has proper provisions, and that the required minimum distributions can be stretched out over the life of the beneficiary and take advantage of that wonderful tax deferral. The first party trust, very briefly, is a trust where the person with disabilities received monies that they should not have received, meaning they received an inheritance, they received a gift of some kind, and it knocked them off of their means-tested benefits. So this is a state and federal sanctioned trust under the OBRA 93, the laws of 1993 of the Omnibus Act of 1993 that changed all the rules in special needs planning. Maryland, through its Code of Maryland regulations, has adopted this, and these funds that came to this person that knocked them off of their benefits can be moved into a first party trust. That first party trust is payable to the state of Maryland if there's anything left at the death of the person, but it does preserve the means tested benefits of the person. The other uses of the first party trust really have to do with, let's say someone is injured in a train accident or a car accident. Those large settlements of $4 million, $5 million, $10 million, they go into these kinds of trusts, generally speaking, not always, but generally. Those trusts are just wonderful tools for the right person. Also, several years ago, the military, the federal government, I should say, allows a person who is receiving a military pension to direct that military pension to a first party trust at their death, and that is a wonderful tool for persons with disabilities. So irrevocable trusts include special needs trusts of the third party type and the first party type. Now, again, this is a little bit of a redundancy here. I apologize. So the third party trust, just to try to frame this for you, this is the bread and butter of estate planning for supplemental needs trust for families that have loved ones with disabilities. It can be flexible and there is no payback to the state of Maryland. The first party trust, there are two different types. The D4A type, that's the kind I was talking about just a moment ago, or the D4C type, which is a pooled trust. And so there are a few of those, and those have their uses. And there are not as many design possibilities in the first party trust because there's an annual compliance to account for these trusts. And also we cannot be too creative with these because they are established under federal and state guidelines. Now a dynasty trust, now we're skipping to maybe the opposite direction here. One comment, I apologize, one comment I want to make before I leave the special needs trust slides is that even though we've been talking about preserving means tested benefits and creating a world of support for those on means tested benefits, not all special needs or disabled beneficiaries are on means tested benefits. And there are lots of them, lots of folks with disabilities that do not receive means tested benefits. So a supplemental needs trust can be used as a control mechanism, as a potential tool if the person is ever on means tested benefits. But I wanted to make clear that not all persons who have or need a supplemental needs trust are necessarily going to be on means tested benefits. So a dynasty trust is a bloodline trust. This is a generation skipping trust. This is a trust that stays inside of this silo, as I'd like to describe it, and it is designed as a lifetime trust, or it can be created at death. And it protects the shares of the beneficiaries down through the generations from the claims of creditors. And again, I mentioned early on, other than those exemption creditors like the IRS, a divorcing spouse who has alimony, or a child support obligation. It also freezes assets for estate tax purposes. So for example, the SLAT can be a dynasty trust. It depends on how it's structured, and it usually is. And that freezes the value of the gift. And that's why we said, well, if that $12 million gift grows to 50 million, well, that extra 38 million of assets that have grown over the years, those are not subject to estate tax because they've grown inside of that trust because the value was frozen at the time of the gift. And the assets, if this is properly structured, the assets are not taxable for estate tax purposes beyond the grantor's generational level. So the grantor establishes this dynasty trust, and Uncle Sam looks at it, looks at that trust at the grantor's level, at their generational level. And then as it goes down the generations, it's never taxed again for estate tax purposes. It could be taxed for generation skipping tax purposes, which is beyond the scope of today's discussion. And there are other disadvantages as far as taxes go. But as far as estate taxes are concerned, it is never taxed again in the estate of the succeeding beneficiaries so long as it's drafted properly. And depending on the jurisdiction, these dynasty trusts can last forever. Maryland has no rule against perpetuities, and that's actually better than Delaware and some other very leading trust states. So Maryland does have a very strong rule about trusts being able to last forever. Now, we talked a little bit about this in the beginning, domestic asset protection trusts. These are asset protection trusts that have been established by statute. And we want to be very careful here because these are called self-settled trusts. And there are approximately 16 to 19 asset protection jurisdictions, including our neighbors in Delaware, our friends way out on the West Coast in Nevada toward the west, Alaska, South Dakota. South Dakota has more assets under management for asset protection than any jurisdiction in the United States. And these kinds of trusts may, and that is a very important thing, may give the settlor asset protection. And they are designed in different ways. Various laws have come down that have made these trusts suspect and available to creditors. So we have to be very careful about that, about where you live when you establish one of these. what type of assets that you are transferring to these trusts. The attorneys that are involved have to make sure that whoever the grantor is, that they retain enough assets, that they haven't impoverished themselves, that there are no creditors on the horizon. Now, there are hybrid alternatives to the domestic asset protection trust. One of those hybrids, or a different type of approach, is the special power of appointment trust, which is generally considered to be extremely airtight against creditors. But this involves the grantor giving up control and letting other special fiduciaries actually make decisions about distributions and so forth. So this takes a lot of faith on the part of the grantor. It also takes a lot of good design so that the grantor retains control over who their fiduciaries are as they decide what their goals are. All planning, especially this kind of planning, is goal driven. So it has to be something that is for the right person, and there has to be a full understanding of the pros and cons of using domestic asset protection trusts. And of course, if it's a completed gift into the trust, the gift is again frozen for tax purposes. So this is an advanced planning tool. I wanted to throw this out there for your information alongside of the specialty trusts that are out there being used, such as SLATs. Now, the community property trust is one of those specialty tools that remains available. And let's say a person has a situation where there's going to be a lot of capital gain. And this has to be a substantial issue. It can't be just a nominal type capital gain issue. Well, what do we know about community property? Well, Maryland is not a community property state, and most states are not. The West Coast states, all the way around the rim, from Texas all the way around generally over to Wisconsin, these tend to be the community property states. And there is a 100% cost basis adjustment, meaning a 100% step up in basis at the death of the first spouse to die, not on the death of the second spouse. So this is a very powerful thing. So for the person who is strongly motivated, the person who has the big need for this, and that has to be very carefully thought through. There are states such as Alaska, Tennessee, South Dakota, where a person can live in another state and actually take advantage of the community property laws through a community property trust. So this is just something that's always good to keep in mind for that right person who may have this specific need. A qualified domestic trust is for a non-citizen surviving spouse. So the United States government looks at assets worldwide. When it looks at who has assets that could be subject to estate tax, it allows non-citizens to use certain advantages, but the United States ultimately says, we don't want a non-citizen spouse to survive, have assets, especially significant assets, and then be able to leave the United States, go to a foreign jurisdiction with their assets, but the United States never got a chance to tax those assets. So for the non-citizen spouse to be able to take advantage, the full advantage of the unlimited marital deduction and other advanced things that are available to, let's say, citizen spouses, there must be a qualified domestic trust established in the estate of the deceased spouse who was a citizen and left assets to their non-citizen spouse. So this protects the US government, and that's why one of the first questions in estate planning is, especially in a couple situation, are you US citizens? The Qualified Personal Residence Trust, as we start to wrap up, the Qualified Personal Residence Trust is a tool to take a residence, be able to have that residence valued, establish a trust for a period of time, 5, 10, 15, or 20 years. You continue to live in the residence, the person who is making the gift. Unfortunately, they have to eventually pay rent. And so this is something that has to really be thought through, but it can be a powerful tool to remove real estate at a discounted rate from the estate of the person who is making the gift. We talked about the Crummy Trust. I apologize, this slide should say $16,000 per year per person, not 15. So I apologize, I should have updated that number. And we talked about Mr. Crummy, and I won't go through that again in the interest of time. This allows you to make an annual exclusion gift to a trust and still have it as a present right of withdrawal for the beneficiary, thereby allowing you to get that money in there tax-free, not having to use anything but the 16,000 exclusion, or to whatever extent that you can use the 16,000 exclusion. A quiet trust is a trust in a jurisdiction like Delaware where the beneficiaries are not entitled to information after a certain period of time. And generally, the beneficiaries have no knowledge of the trust's existence. This is really not provided for in Maryland law, unfortunately. There are some things under the Maryland Trust Act that almost make us think that there can be the use of a quiet trust, but in reality, Maryland does not provide for this. So for better or for worse, and I would say generally for the better, trusts in Maryland are not quiet, but you can achieve a quiet trust in another jurisdiction. These are irrevocable trusts, and in Maryland, beneficiaries under the Maryland Trust Act from 2014 are entitled to all information, and I would argue literally all information if they are requesting that information, if they are a qualified beneficiary. The standalone retirement trust, which I believe is the last trust we're going to review today, is a trust that is designed for several reasons. It stands on its own, just like the title says, and it encourages a person, a client, let's say, to leave their significant retirement assets to a trust that is specifically designed for retirement plans. Now, it is possible to not use the standalone retirement trust and to leave a spendthrift trust or further trust for beneficiaries, and to commingle IRA assets with non-IRA assets. So that is certainly possible, but especially for larger IRAs, this is a standalone type trust that encourages the beneficiaries to respect their IRA assets. Now, with the Secure Act, and with most beneficiaries being healthy and well, and they are subject to the 10-year distribution rule, the use of standalone retirement plan trusts needs to be carefully looked at as to whether it still provides a benefit. But for certain types of beneficiaries, spendthrift beneficiaries, beneficiaries that need a protection from divorce or management, the grantor can exercise control here, okay, by using an IRA trust. Now remember, IRAs that are left to individuals have no asset protection according to the Supreme Court. So you have asset protection in your IRAs or retirement plan assets, but your beneficiaries who receive an inherited IRA, they have no asset protection. So we want to encourage you to use a trust to leave IRA assets to, whether it is a standalone trust like this or a regular further trust for the beneficiary under your will or trust. And these trusts, we don't have time to go into this today, they can be drafted as what is called the conduit trust or the accumulation trust. For example, in special needs, we almost always draft a trust as an accumulation trust where the IRA assets stay in the trust until they're distributed. There are certain tax ramifications of that. And then in normal planning, so to speak, where we use a conduit, that means that IRA distributions, if they come out of the IRA, they must be distributed to the beneficiary. And there are pros and cons of that as well, depending on the beneficiary. So just know that standalone retirement plan trusts are irrevocable trusts that can be used for tools, especially for large IRAs. Now, a brief overview as we start to wrap up, taxation of trust. We talked about this very briefly. The revocable trust is a prime example of a grantor trust, a trust that does not pay its own taxes, but the grantor pays the tax. A life insurance trust is a prime example of a typical grantor trust where the grantor pays the tax and not the trust. Grantor trusts are juxtaposed against non-grantor trusts. So spendthrift trusts at death for those children and beneficiaries like spouses or nieces and nephews are non-grantor trusts. They pay their own tax. Charitable trusts are non-grantor trusts. Tax reporting varies depending on who you talk to, who your CPA is, but generally speaking, trusts have to have their own tax return. It can be accomplished otherwise, but in the highest and best practice, generally speaking, a trust will have its own tax return, a 1041. Income gets carried out to the beneficiaries in typical trusts like spendthrift trusts at death. Capital gain can actually be carried out to the beneficiaries as well and managing trust taxation is one of the big issues. I apologize that I won't be able to spend more time on this slide today because we took just a little bit of too much time going through those irrevocable trusts, but in further presentations, we will talk more about the taxation of trust. Probably after all of this information today, it's probably best that I'm not getting into the taxation of trust, but just take this slide as a brief overview of what we want to consider in the taxation of trusts. Now, flexibility. We want to be talking about, for new trusts, trust protectors, which are special fiduciaries, special independent trustees. For domestic asset protection trusts and advanced trusts like SLATs, we can have an investment direction advisor, a distribution advisor, an independent distribution advisor. So we want to have very robust powers under powers of attorney. We want to understand how trusts can be flexible. Older trusts, there are different ways of changing those older trusts if we're lucky enough under the terms and provisions and the state law of those trusts. If we're lucky, there are some new ways of doing that, such as decanting, which is actually changing an old trust into a newer trust, a completely new trust, if that's possible, a non-judicial settlement agreement, and other types of agreements where we can actually change trust. Trust protectors have the power, generally speaking, to make amendments to trust, but not extreme amendments. Those types of things might be the subject of decanting. But trust protectors are a basic form of flexibility that we want to have in trust. And for old trusts, if we can revise or amend those old trusts to include trust protector provisions, many times that is a wonderful thing to do. As I mentioned, the older trusts don't have any built-in flexibility like new trusts do. So does the person who is the agent under the power of attorney, do they have powers to change a trust or to modify a trust? The trust could be modified by the terms of the trust itself. So many times the first thing we look to is the trust terms and provisions. Does it allow for modification? As I mentioned, a non-judicial settlement agreement, that is a relatively new tool. Decanting, Maryland does not have decanting, but our neighbors in Delaware and Virginia and about 20 plus other states have decanting, so we want to use that where it's appropriate. We have to be very careful with decanting. It's a very, very scary power. We want to use it judiciously for the right purpose. And of course, there's court modification or reformation of trusts. So remember, as we think through irrevocable trusts, and then we'll wrap up, I like to think of irrevocable trusts as trusts with a special purpose. Those trusts satisfy a goal or a need, and that's what all planning should be about, goals or purpose. It provides a benefit of some kind or a protection. It has various tax aspects which we have to consider as we create such a trust as to whether it's appropriate. It has flexibility components, ideally, and if it does not, hopefully there's a way to add those through some kind of back channel, as we just mentioned a few minutes ago. The client can control certain components of the trust, or other types of irrevocable trust, the client has given up all control. So that is a case-by-case situation. And we always want to think about the advisory team, the attorney, the CPA, the financial advisor, the life insurance specialist, or in the case of elder care, even a geriatric or life care manager. We want to think about how this advisory team will support the planning overall, no matter how complex or wonderful the planning components are of these various trusts. So why is client education so important? It's the driving force as far as we're concerned. And once a client is or advisors are educated about these tools, we can just get ready for this wonderful ride where we know these kinds of tools are available to us. It gives clients space and time to think about what's important, what drives their goals and values. It gives clients assurance that they need this kind of assurance when they are making these big decisions to use trusts like this, that these trusts are proven, that there's a valid need for them, and if they need to be changed, that there's flexibility. It keeps us apprised of changing conditions as we look at the types of tools that are available to us. It can keep the client in some kind of what I would call modicum of control. Certain trusts do, certain trusts don't necessarily do that. It builds trust in family relationships. So let's say someone puts an advanced structure in place, but they make sure they educate everyone involved where it's appropriate. Now we have a building of family relationships and knowledge about what is happening. And it facilitates planning that actually works the way it's intended to. So whether you are an advisor or a client or a prospective client, we want you to set a consultation with us to talk more about these issues. Specifically, what are your goals? We want you to ask questions. We want you to know there's nothing to fear. We want you to know that your time and attention is appreciated as you sit in a conference room like I'm at right now, conference room number 1. At Elville and Associates, we have all the latest technology. This is really a place to learn, to talk about goals, to talk about family, and to talk about educating them and your advisors. Consider whether you have an advisory team. If you don't have one, we want to help you establish one. If you do have one, we want to talk about how to best work together. And that is very important because we want to bring to bear all of that knowledge about taxes, the financial advisory side, the legal side, all of it together. We don't want to leave anyone out of that process that is beneficial to the client. Questions, we love questions, please bring them. If you're an advisor, please have your client formulate their questions. Bring current estate planning documents. The whole purpose is to educate and to provide clients with time to think. And if you don't know what your goals are, if you're a client, we want to help you facilitate what those goals are or to develop what your goals are. So with all that said, I've gone over maybe 5 minutes too long today. I apologize, Jeff. I want to wrap up now and thank everyone for their time and attention. Hopefully, you're taking something substantive away from the presentation materials and some of the comments I made today. Have a wonderful day and the rest of the week.
Well, thank you, Steve. Really great information as always. I think a lot of people tuned in for your comments and thoughts about irrevocable trusts and their purposes today, and you certainly delivered that today. So thank you very much. We do have a few questions. I know that time is a little bit short. I know you have an appointment coming up here rather shortly. So if you okay, we'll just jump right into it here. So we have non-grantor trust. Person creating the trust and gifting to it lives in Maryland. Beneficiaries live in Florida. The trust will invest in financial investments. Which state would be the jurisdiction for the trust, and which state would try to tax the income of the trust?
Well, that's a wonderful question. I think as a very basic answer, it sounds like that you've established a Maryland trust. So Maryland would be the jurisdiction for state law purposes. And I think that until you change the situs or state law of the trust, it remains Maryland. The trust is basically going to be taxed for income tax purposes in the state where the trustee lives. And I think there's a lot of controversy about whether Maryland has the right to tax certain trusts. So I think it depends on the type of trust you have drafted. And I would hope that it's only going to be the state of where the trustee lives, and that Maryland would not try to tax that trust. But that would be something that we would have to meet and discuss. Thank you for that question.
Okay. Do assets grow tax-free in a Medicaid or Veterans Trust? What happens to assets placed in a Medicaid or Veterans Trust once the person passes away?
Well, that is a great question. So the assets that are gifted to a Medicaid trust, it's going to depend whether it is a completed gift for tax purposes or not. Now, many times these trusts are drafted as completed gifts for Medicaid purposes. I hope this is not too confusing, but incomplete gifts for federal income tax purposes. So the answer is no to the first question if it is a typical Medicaid trust. But after the death of the grantor, those assets go with no probate to the trust beneficiaries. And there, in a Medicaid trust, there are lifetime beneficiaries and there are death beneficiaries. So the assets are going to pass to the death beneficiaries with no probate, and it's going to be treated just like it would be if you had left assets to them through a will or a revocable trust.
Okay, great, thank you. Do assets in a minor's crummy trust count against FAFSA for college costs?
Thank you for that question. My general answer is yes. My general answer is that that's going to be a concern, and I'm shooting from the hip there, so that's not legal advice, but my general feeling is that that is going to be an issue. It has to be addressed.
Okay. And it looks like we have one more here. If a client plans to annually give the maximum allowed annual exclusion gift, can there be one crummy letter given to the beneficiaries for the first gift only, letting them know there will be a gift each year at the same time and will have the same 30-day right to withdraw, or do we have to do it annually?
That's a wonderful question. I would want to look at your crummy letter, and I would say that there is a possibility of limiting the amount of the withdrawal, not only the question of how many crummy letters do you have to give thereafter, but in the crummy letter itself, it's possible to have language that says you're not necessarily allowing the potential for the full withdrawal of the entire annual exclusion amount. But I think as a conservative approach, I would send the crummy letter each and every year when you make the gift.
Okay. And one more, you may have answered it, but we'll pass it on to you. Is the standalone retirement plan trust mostly for creditor protection?
Yes, it is, but in another sense, it's really designed to segregate the retirement asset from the revocable trust. Let's say a person has a revocable trust plan. And we know, and in the interest of time, I'll try to be brief, we know that some attorneys will recommend that an IRA be beneficiary designated into a revocable trust. And so that IRA assets goes into the trust. And if that trust is considered to be a see-through trust, which is a subject of another discussion, then the IRA will go through that trust straight down to the beneficiaries as if the trust does not exist. The problem happens when someone, a well-meaning person, says, well, I have charitable gifts and I'm putting those charitable gifts in my revocable trust as one example. Now the IRA goes into that trust, it comes down through, but the problem is it now hits one of those charitable gifts, and that is a no-no. Uncle Sam says that an IRA must go, if it's going to qualify for the see-through trust rules, it must go to people and not organizations. It must go to someone with a heartbeat. So if it hits that charitable beneficiary, for example, as one example, now the IRA will implode and not have any tax deferral at all, and will have to be distributed immediately or under what is called the 5-year rule. So one of the reasons to segregate out a large IRA into a standalone retirement trust is just to make sure that you never fall into that trap where there's something that's in your revocable trust, and if you inadvertently or your advisor inadvertently titled the retirement plan asset to go straight into the revocable trust, that you didn't inadvertently have a problem there that causes the implosion of the tax deferral. Now, there is a way to deal with that for charitable gifts, and the example that I just gave to you, but let's say the attorney handling the administration doesn't think through that issue, or your child or whoever your fiduciary is not using an attorney. We don't want the immediate taxation on all the IRA assets. So it is for asset protection, but it's also to segregate out large retirement assets from non-retirement assets and avoid problems associated with what I just described and other problems.
Okay. So our financial advisor friend Kelly says, thank you very much. Very well explained.
Oh, thank you. Thank you, Kelly.
Okay, so again, thank you everybody for being here today. Wonderful questions, Steve. Great job as always. If there's anything we can do for you with this topic or anything related to estate planning, elder law, special needs planning, estate and trust administration, certainly let us know. Be happy to be a resource to you. Email Steve, email me, or his executive assistant, Mary, Elville@associates.com, as my light goes off. And we'll be happy to be a resource to you and get you set up and come in to see Steve. So thank you for being here. Look for my email, as I always do, as I try to follow up with you with some information, and look forward to seeing you again soon on the Elville webinar series. Have a great day, everybody.